But this writ petition was filed by the Honorable Chief Minister. That challenging Karnataka, denotification is nothing new. Whether he voted for BJP or Congress, he said neither I voted for Janata Dal. So why should I suffer because of all
this? You have to suffer because you are the Janta.
And I am likely to be arrested at the age of 80 years for something that happened 24 years ago, please, Your Lordship. So I am in 20.1 and 20.2, which I respectfully suggest first take up. Because Lord, I don't want to get caught in this fight. I am a poor man who has been dragged into it, and Lord, the learned single judge has damned me. And I am likely to be arrested at the age of 80 years for something that happened 24 years ago. So Lord, I have a slightly different issue. I am not on this.
Whichever appeal is substantive, in your view, will take up first.
Sorry?
Whichever appeal is substantive.
Lord, mine is.
Your perception will take up first.
Lord, mine is a very substantive issue because I was not a party.
By serial number.
Yes, I was not a party. And unfortunately, Lord, what has happened is in my absence, the learned judge has not condemned me beyond imagination. That's why I am before your lordships. So, Lord, I am ultimately now, Lord, facing a prosecution. Learned judge has commented upon the merits of the prosecution and has left no remedy now available for me. So, Lord, I would like to show that.
My Lord, in 20.1 and 20.2, I appear, my Lord, for respondent number 4 and respondent number 1 respectively. Your Lordship may kindly see 20.2, my Lord. The only order that has been passed by the learned single judge.
It's my petition. Why do you want to interrupt just now?
Is to
Mr. Raghavan, it's my petition. Please allow me. Do you have any preliminary objection or what?
Yes, with respect to 20.2, yes.
By suppressing vital documents, these orders have been taken. I will show to your lordships.
We will consider.
Sorry?
You are seeking leave to appeal.
Yes, Lord.
So we will consider.
Yes, Lord.
Let the first main subject matter be addressed.
Lord, your lordship may take up his matter first. Well, your lordship may take up his matter first. I'm in the first matter. Let that be done first. No problem. Lord, I am grateful to Mr. Singh. Lord, just turn to page, Lord, 88.
Which one?
Take up Lord 1713 of 2024. 20.1.
But all will travel together. We may take up first, no difficulty.
Yes.
But all three appeals will travel together.
Yes, of course. But Lord, I stand slightly on a different footing because I was not a party and I have suffered. Lord, one principle that has been settled.
We understand, but even then, all matters will travel together.
Of course, Lord, they will
travel. As far as the procedure and discussion.
Today, I am more anxious than them because I am facing, Lord, this condemnation in my absentia.
All are appearing in your matter. All respondents are appearing.
Lord, they will.
Notice.
Your Lordship.
Notice may have to come.
Notice may have to come. Last time they appeared, Mr. Maninder Singh, Mr. Raghavan, learned Solicitor General, they were all there. I don't know which matter they appeared.
Notice is not an issue. Notice may have to go.
Complainants are on caveat, Lord.
Yours is 1713.
Yes, Lord. And 1719. Both.
But right now, leave to appeal is 1713.
Yes, Lord.
Who are the respondents? All are appearing?
Lord, they are on caveat. Yeah.
Number 3 appearing.
Page 6, Lord, they are on caveat. The complainants.
20.1, my Lord, respondent number 4.
3, 4, 5 are on caveat.
Notice may have to go to respondent number 2, my lords. I'm appearing for the state in this matter. I'm appearing for the state. Appearing for the state. Number 1, please. But the notice will go to number 2 and 5. 2 and 6. I had appeared before the learned single judge. Notice may have to go. Only after that, probably.
Lord, I am really not concerned about 17A order by the Excellency, the Governor. That's between them.
My Lord is saying all must struggle together. That's in that context. My Lord, only thing that you may be separate.
Yes.
But at least in hearing part, we can't disconnect the things. That is what we are suggesting.
Lord, I would respectfully urge.
We'll treat you separate.
Yes, Lord.
You are separate.
Because Lord, I am getting dragged at the age of 80 in this, Lord.
No, there is
slugfest. I have nothing to do with politics.
You remain Jal Kamalvat.
I asked my client whether he would. So, Lord.
Tortoise in a water doesn't have the touch of water.
Yeah, that's
so we'll keep you like that.
Very well.
But still, it will be in the water.
Yes, yes.
So, notice.
Yes, Lord.
Please take.
Lordship, Lord, I have one prayer. Lord, last time what happened, your Lordship knows by consent on 22nd it was adjourned. And everybody had agreed that learned single judge would be requested to Lord adjourn the hearing. Lord, my distinguished friend, Mr. Raghavan was not in the court before your Lordships. So before the learned single judge, he Lord stoutly resisted a request for adjournment. So it should be understood, now learned single judge has kept it on 10th. Either your Lordships keep before 10th, I have no problem. Otherwise, Lord, if your Lordships are unable to fix it before 10th, then your Lordships may, it should be understood by all parties that matter. Otherwise, it will become infractuous, completely infractuous.
Why infractuous?
Sorry, because the learned single judge is now, Lord, post-haste wanting to transfer the proceedings to CBI.
We do not.
That's a petition filed. That's what petitioners want. Learned single judge has issued notice on that.
How can you foresee a decision in any matter?
No, not foresee. The petitioners are insisting. Petitioners are insisting. So, Lord, I am respectfully submit. Either your Lordships may protect me or your Lordship. It should be understood. I am in your Lordship's hands.
But can I make one submission?
I am seeking, Lord, ex parte stay today.
Can I make one?
Undoubtedly, because no, I'll show to your lordships what wrong is there in learned single judge, which is hurting me very
Who are you,
seriously.
by the way?
Lord, I am a farmer who in 2004 sold this land to the Honorable Chief Minister's brother-in-law, not knowing what is going to happen in 2024.
Why you are?
But I've been, my documents have been set aside by the single judge. Single judge says I am party to fraud. Single judge says I am liable. Single judge says I should face prosecution.
Why you are so much bothering after this much years?
No, my lord, why? Why should I at this stage and age, my lord, face this?
That will examine.
Lord, my life and liberty is at stake.
What Mr. Raghavan is saying, yes.
Well, can I make one submission, my lord? My lord, the anxiety that my learned friend is showing with respect to the hearing on the 10th is in 20.2. Please see the order that has been passed by the learned single judge against which this appeal is filed. All that the order says is, my lord, issue notice.
No,
It is
the
against
last order.
That is all the order that has been passed. Nothing more. I ask myself, how is an appeal maintainable against an order simply issuing notice for the learned single judge? This is all that there is in it.
See the last order, Madam Court.
Please see, my lord. Please see the order.
I will.
Kindly see the last order. Learned judge now has peremptorily fixed it.
It is 511 order.
No, subsequent order on 10th. 26, on 26.
My lord, what is challenged, my lord?
The understanding is matter would be heard on the said date. Now, my lord, they can't seek adjournment here. And kindly hear me on, my lord, ex parte stay. I'll persuade your lordships.
Sir, my lord, my objection is to the maintainability. I am now saying,
The law Ayukt is directed to place on record the investigation.
that's all.
Yes, correct, but my lord, it affects me. I am talking about Article 21, my lord. Why should I be condemned without hearing? Lord, it goes to the root. There are 100 judgments of Supreme Court which says that if you have not been heard, it must be set aside. It's a simple thing, my lord. I'm praying to your lordships. Nothing, my lord, big.
Record of investigation conducted till particular date is ordered.
If this judgment qua me goes, this order goes.
There is no expression of opinion.
Nothing.
No, nobody is saying. In this judgment, there is an expression of opinion. 1713.
The matter coming
That
up
is consequential.
No.
That is a second petition they filed.
So you are saying that the proceedings may not go because
Yes, please see this, Lord. Kindly turn to page 88.
we are the least court to interject in the proceedings of other court.
I am not wanting your lordships to interject in other court. I am wanting your lordships to protect me here. Please turn to page 88. Let us see what the learned single judge has done. Kindly turn to page 88. I am only on my Lord case and why, Lord, I should be protected. Page 88, Lord. Please see the first issue. Lord, this writ petition was filed by the Honorable Chief Minister challenging the sanction granted by Honorable Excellency the Governor under Section 17A of the Prevention of Corruption Act. It had nothing to do with the complaint. Now see first issue that learned judge framed. Whether the petitions before the Governor and the complaints before the concerned court were justified in the fact situation. Page 88. Page 88, issue number 1. Whether the petitions before the Governor, fair enough, that was the subject matter before learned single judge, and the complaints before the concerned court were justified in the fact situation. Now, complaint is against me also, I'm accused for. I'm not a party here. Learned single judge without any necessity because the issue only was whether Honorable Governor was right or wrong. Now please see finding at 232. And before I show other pages, please see 232, Lord, straight. Please kindly turn to 232. Summary of findings. I have been condemned, Lord. I have no remedy now. The complainants were justified. 232, Lord. First finding. Complainants were justified in registering complaint and seeking approval at the hands of Governor or seeking. Registering complaint. Now, which Lord, trial court today will give me benefit? Now, see the findings against me at pages Lord, 93 to 97 first. 93 to 97, Lord. Lord, I'll tell your lordships briefly what happened. Lord, this is just kindly give me five minutes, Lord. Lord, this is a land which has been in my family since 1935. Lord, in 1968, Lord, this land was relinquished by me in favor of my elder brother. Then it so happened that elder brother went into debts. And Lord, he passed away, unfortunately. His wife, son, and the other surviving brother, all of us agreed, appeared before the revenue authority in what is known as the inheritance khata, as my lords would tell. In Lord, the authorities recorded that my brother's widow, her son, and my other surviving brother have now relinquished the right in my favor. The land was accordingly transferred in my favor. All these facts are suppressed from the court. And suggestion is being made that although you are not the owner of the land, you sold it in 2004. Now, which is incorrect because it is recorded on revenue and all the records are before your lordships today. I can show. Now, my lord, that happened. Then, my lord, the acquisition proceeding started. And before my lord, in respect of my land, an individual award was made. I had moved an application for withdrawal of the acquisition under section 48 for denotification, which was recommended by a committee consisting of large number of members, including members from the Bharatiya Janata Party, Congress, Janata Dal, everybody in Muda. It was sent to the government. A committee of 6 secretaries of government of Karnataka considered that, and along with some hundreds of cases, denotified my land. I am not the individual alone who is benefited. Now, if that be so, then that denotification. Now, see at page 97. What does the learned judge say? Please see. After recording, and unfortunately, the petitioners did not inform the learned judge of full facts, although they got full record, but they selectively placed it before the learned single judge. So, I don't blame learned single judge for these findings. It's the petitioners who have misled the court. 97, just first at the top. Based upon the said proceedings, and notwithstanding the fact that the amount of award was also deposited before jurisdictional civil court. Now, civil court returned that amount, which they don't disclose. Civil court said that the amount is not deposited for individual plans. The land comes to be denotified. This, on the face of it, is illegal act on the part of the state. Now, denotification in my favor in 1998, learned judges commented in 2024. My right to property is seriously affected. It's a constitutional right under Article 300 capital A. And I have sold it for a valuable consideration under a registered sale deed in 2004 for 5,36,000 rupees. Now, please see at page 100. Please see. Page 100, my lord. First paragraph, last 5 lines. Muda does not stop at that. Continues to form layout and distribute sites in favor of allottees. From 98 to 2003, owner of survey number 464 is shown as Muda. Encumbrance certificate also reflects Muda. Upon date of acquisition, it reflected name of Malharaya, nowhere reflected name of Devaraju. Now, this is absolutely incorrect because the land record shows my name again and again for various years. From 91-92, which was not brought. Here springs the picture, family of Chief Minister. I am not concerned with it. Devaraju, who claiming to be son of Ninja, para 21, executed a sale deed in favor of Mallika Jodnaya. He is a brother-in-law petitioner. Sale deed is executed on 25/8/2004, but sites were formed. Now, sale deed in 2020 years ago. Who knows what will be the value in 2024? Learned judge says in 1935 value was 300 rupees. It is today 56 crores of rupees. Lord, how am I concerned as a small man? Now, Lord, please kindly turn to page 104. Brought the learned single judge. Please see at the 103 foot. What is discernible from the sale deed is none of the factors that have happened from 92 are even noticed. Devaraju was aware that subject land was included in preliminary notification. He was award final notification included. He submitted representation for denotification. Passing of the award is within knowledge. Deliberately, all these factors are suppressed and a sale deed is executed free from all history. But the land was already denotified. What is there to tell in the registered sale deed? Right or wrong? Nobody questioned it. And my lord, your lordships are aware, my lord may perhaps tell your lordships, that in Karnataka, my lord, denotification is nothing new. Because my lord, the farmers represent to the government and the government considers it. Now, my lord, right or wrong, in 1998, denotification took place. 1998. Now, all right, if you want to damn me, at least the learned judge should have told the parties that join Devaraju as a party. So, my lord, without joining me, the learned single judge, my lord, has... Now, what is the consequence? Show me that compiled this note.
I don't want to interrupt my learner. I have a small suggestion. This is a matter in which your lordships will consider it right or wrong. If your lordship decides to issue then the matter will have to be heard. Now, if your lordship don't want to dismiss it ex parte and issue notice, then let it be heard. Right, all parties should judge. Ramification.
Kindly give.
Right.
We will not kindly see the law. Lord, your lordships are aware, but Lord, as recently as last week, I was sitting in Court of Justice, Dipankar Datta, Lord, and lordship set aside an identical judgment of the High Court where Lord, observations were made and decision given against the party who was not before the High Court. Now that law is settled, your lordships are aware. My difficulty is that I am criminal complaint is filed against me. With these findings, my lord, the criminal complaint, I will have no defense left.
My lord, can I make one submission, my lord? The matter.
One second.
Yes.
All arguments of yours are liable to be considered on merits in respect to your prayer to leave to appeal, but not in connection with the staying of the proceeding to learn a single.
No, my lord, once your lordships grant me leave, I have a right to persuade your lordships to protect me. I am not, certainly, my lord, your lordships can't say that once your lordships grant leave, my lord, it's a right to appeal. And in appeal, I have a right to seek stay. Please don't drive me, my lord, from one court to the other. We are only respectfully urging your lordships that please don't.
All our jurisdictional courts. Go there and whatever you request there, we are not coming in way.
No.
As Mr.
Lord, please see this.
Sibal is trying to balance the things.
My lord,
What I'm trying to say,
learned judge, my lord.
all parties, because this matter has ramifications. It's not just this matter. Connected matters have ramifications,
Both.
right? So it should not be that the right to appeal is lost by some peremptory order passed by the learned single judge. That's all that I am, as a state, concerned about, Mullahs. Either way, I'm neither for Mullahs this side or that side. But Mullahs, therefore, there should be an understanding that
But we are in
till such
entirely
time as
your
your lordship
lordship's
till such
Your lordship may decline me.
such time-
I have no problem.
this time, no, one second.
If your
Till
lordship
such
are
time,
not
all
persuaded,
parties should agree.
I can't go beyond that. I can only persuade your lordships.
No, I'm
Ultimately, I have to bow
suggesting-
down. I have to bow down to your lordship's decision. But I need protection because not at 80 years I don't want to face the criminal court. I don't want to face not police and CBI. Why should I do it? I have nothing to do with them. I sold it. But if today as a lawyer I sell land to somebody and in 20 years later if it's found that he is into criminal activity, should I be held responsible?
My lord, can I make one submission if my learned friend will kindly my lord?
The only application probably would be, my lord, is it fixed at 10, 10
Right, a peremptory order passed by him.
Can I? No, my lord. I will tell your lordships, my lord, what happened.
Raghavan, you should have joined me as a party. Why were you shy?
One minute. Sir, I am not.
Join me.
With which petition? I am not the petitioner.
No, you took in your counter, you have made allegations against me. Despite the fact that it was governor's order, which was
I
in
am not the
consideration.
petitioner. Mr. Dave, I am
I will
not.
show your counter, Mr. Raghavan.
I am not the petitioner.
Serious allegations.
The petitioner is not me. The petitioner was Mr. Siddaramaiah. I was
Petitioner
not.
did not do anything.
I was a respondent.
It was your counter which prevailed upon the learned judge.
Don't keep saying I should have made a party. How can I make you a party?
Mr. Raghavan, why are you not here today when we are here? I thought I would at least like to see you.
I would have loved to, but I had some other commitment which was a little unavoidable. Otherwise, I would have never missed being with you. And in the distinguished company of all of you, I would have loved to be there. Can I make one submission, my lord? If I am permitted.
Sorry, yes.
My lord, the only order that has been passed in the writ petition is to issue notice. My learned, whatever my learned friend has told your lordships, my learned friend can tell the learned single judge. And in the only prayer in that writ petition, which is coming up on the 10th, is to say, instead of having the Lokayukta police to investigate, please refer it to CBI. Whether the court will do it, will not do it, in respect of whom the court will do it, these are all matters left to the learned single judge. My learned friend may be very right in what he
If
says.
it is so simple, why don't you agree for an adjournment, Mr. Raghavan? You know what you are trying to aim.
Sir, let me complete.
We all know it.
I am just.
It is a serious issue. It affects the liberty of a citizen.
One minute, my lord. All these high-flown words. All that I am trying to do, my lord, is to persuade this honorable court to simply leave it to the learned single judge. My learned friend, whatever he is saying today, can tell the learned single judge. Learned single judge may do whatever he thinks is appropriate. And now, my lord, against an order saying issue notice.
So if the
My lord, what is this appeal?
What is this appeal?
if the request is
Yes.
made by Mr. Sibal to learn a single judge on 10th, as he is suggesting, what you will do?
What I will do, my lord? I will tell you, lord, what I will do. I will try to persuade the learned single judge to take it up.
We end here as far as commenting your suggestions are concerned, and we leave it to it. But we are not going to pass any.
Right. Very.
We understand the anxiety, but still we are a different court. Not like to
No,
influence any proceedings.
I am only on my appeal. Lord, I am on my appeal. Your lordships may kindly consider and record my prayer for stay. That's all. Your lordships may decline it, no difficulty.
Today we are at the stage of granting or not granting leave to appeal.
Lord, once your lordships grant the leave, if your lordships are not inclined to grant the leave, I will bow down. No difficulty, my lord.
Therefore, we are hearing all in that respect.
No, my lord, I am saying that you please protect me. I can't be without a remedy. Lord, if your lordships are not inclined, I have a remedy in the Supreme Court. Lord, I can't be left without a remedy. With greatest respect, let me tell your lordships, I am today vulnerable. I am whatever Mr. Raghavan says. My lord, they are pressing before the learned single judge for hearing of the matter.
My learned friend will oppose my prayer.
And my lord, in the second matter, I am party.
In the second matter, the only issue
In the
notice.
second matter, I am party, and I have filed appeal. There is no leave there. So, my lord, either your lordships may request all parties to stay their hands off till your lordships decide it. We would be more than happy. 1 day is not hearing.
But he's not.
Heavens are not going to fall. 24 years it has waited. Why should not my learned friends insist? What will they do? Well, just look at it. The Lokayukt court issues a process, direction to the police to investigate. As soon as that is done, a petition is filed on the same day before the learned single judge CBI. Now it is at their prayer, at their petition for Lokayukt investigation that Lokayukt court intervened. Lokayukt police was directed. Now he moves the single judge by writ on the same day and says now CBI. Tomorrow he will say now ED. Third day he will say something else. Well, are we going to be subject to this kind of vexatious prosecutions? It is a vexatious prosecution so far as I am concerned. I am not concerned about the Honorable CM and others.
By making any observation, we would not like to enter the mind of learned single.
No, I am not saying that. Your lordships may protect me or request the learned single judge.
But whatever we observe in black and white or even orally, it will influence the proceeding. That we don't want. Very clear.
Certainly, but your lordships want learned single judge to proceed. Then kindly,
nobody prevents from you to requesting. And no.
Why should I be? I am before your lordships. I am seeking your lordships' indulgence in the second matter. Kindly grant me stay or say no. Lord, your lordships can't say that your lordships will not be able to protect me when we are saying it has been peremptorily fixed at 2:30. And my learned friend, despite last understanding, resisted tooth and nail. Mr. Maninder Singh, his lead counsel, agreed before your lordships. And it was because of a very joyous occasion in his family that we were...
I think Mr. Dave can control himself as far as our domestic affairs are concerned. It's very unfair on his part.
It
was unfair on that day. There's no need to tell what is happening in our domestic affairs.
No, you did agree. That's all I'm saying.
No, but there's no need to add some qualification to that. Last time also you did it, I didn't anything.
What is wrong?
This is a Mura Kushti going on between two parties. One doesn't plead the other and the other comes up and asks for stay. It is a pure Mura Kushti going on.
Very well. You know what you are doing by filing this so-called public-related petitions.
Yes, we know.
After 24 years. Yes, said better, Mr. Maninder Singh.
Yes, please, let's set the better. You should have stopped yourself.
SLP.
A subsequent complaint before the Lokayukt SP and a private complaint before the special court, my lord. He is being shown as the accused. It's not, my lord, pursuant to the judgment passed by the learned single judge that is now being made the accused. That's not so.
Exactly.
It's being portrayed as though he's being now freshly made the accused pursuant to the order passed by the learned single judge.
You are absolutely right. I agree. With no defense left. That's my request.
So these are not observations, my lord. These are mere contentions.
No. What are you saying?
Observed.
With great respect, don't be uncharitable to the learned single judge. These are findings. Historical findings of facts.
If it is, my lord, we will examine, my lord, as to whether any findings have been recorded by the learned single judge against Mr. Dave.
Have read the judgment by Mr. Raghavan.
I mean, it can't be rushed like this. My lord,
Developed layout was alienated, portraying as though it's an agricultural land.
and this order, my lord, was passed 2.5 months ago.
This 80-year gentleman in
Dr. Singh is appearing. I'm for the state.
Please.
Yes.
Same order appearing except for the common law. Same order needs to be issued in all three matters. Please. In first and second matter. Please, my lords. In the third matter, all are represent. Except for, my lords, notice will have to go, my lords.
In fact, for His Excellency the Governor, the Solicitor General has already taken notice. Court may kindly recollect. It was at his instance the matter was urgent. No, when the date was fixed, mention
We jointly agreed on 5th.
he mentioned was
Should have all been here.
at his instance.
We agreed.
Please to
No, notice,
an agreed
formal notice has to go, my lords. Formal notice may have to go, my lords.
Very well. But
Can I, if I may request, my lords, in WP number 1719, notice may have to go to, there are quite a few respondents, my lords. The first,
What is 170?
Which date do you propose next?
whatever your lordships take
We would like to have it done as quickly as possible. Because this will at least
some time.
take time for hearing.
Definitely some time it will take.
Well, your lordship will hear me on 20.
What is your main matter? My main.
Item 20.
Well, sorry, not for the state. Main petition. As well as
Dr.
Dr.
I
appear for Dr. Singh.
My video was can I make my submission?
Main plan.
Yes. May I make my submission in a coherent manner for 10 minutes?
Just highlight, nothing more.
Yes. Now, I am here and I would be using only two documents. One is a list of the findings of the learned single judge and the error thereon. And the second will be the written submission in more elaboration as to why that's an error. Now, the principal error are the following. Number one, that your lordship's has got a 17A situation here.
Is it about the validity of the consent itself?
Yes.
It is about 2 or 3 things.
Or is it
First
about
is
the about the scope, implementation, and the
no. So let me explain.
import
Let me explain.
Article 163. What is
I just started. Give me a few
the
minutes.
stage? I
It
will
is-
take
it
about
is-
5 to 7 minutes after he has finished and give your lordships a gist of what the issue is. Let him
So,
finish.
as far as I'm
Interrupt.
So as far as I am concerned, Velas, for the appellant in item 20, my submissions are these.
Yes.
First, Velas, is that 17A has been completely violated. The requirement and mandate of 17A that there has to be a filter of a police officer has been violated, and despite that, wrongly upheld by the learned single judge. A private complaint, Velas, or any other complaint must go through the filter of a police officer is the first submission. And 17A has been completely violated. Here he has gone straight to the governor. Number two.
You need not. 2 years.
Number two, well, and this is a very large and very serious constitutional issue.
Yes.
Well, it's the law generally decided even by constitution benches till last year, Subhash decided, is that the governor is and must be bound by the aid and advice of the cabinet. Number two, there are well-known exceptions to it. It is not that he is always bound. One exception is if there is clearly,
In this case, whether it is a subjective discretion
so therefore, immediately, allow me.
or constitutional discretion. That is
Exactly. Now, let me. Here, Malas, I am now coming to the exception. The exception is where there is manifest irrationality. Where there is manifest irrationality, that's the word in the test used by the Supreme Court, in the sanction, refusal, or order regarding sanction by the state government. Now, Malas, the learned single judge on the contention of the other side misreads that exception.
so many.
Of January, some date, my lord.
It is the foundation
Second
for
of
the
January.
one case. No
Around the
position was
14th
taken.
or
Malas, 13th.
13th of January.
13th, Malas, 13th.